Caveat emptor, or buyer beware, is a long-standing legal principle that generally places the onus on buyers to satisfy themselves about property or goods before purchasing, meaning the buyer assumes the risk of defects or issues unless specific exceptions apply. Under caveat emptor, a seller is not automatically responsible for problems that a buyer could have discovered through reasonable inspection or inquiry, and the buyer cannot later claim for defects that were apparent or should have been found at the time. However, there are important exceptions to this rule, where buyers might have legal recourse, including misrepresentations by the seller, where incorrect statements about the property induce the buyer to enter into the contract, where there are statutory warranties or protections in legislation that impose obligations on the seller, and where the seller fraudulently conceals defects or important information that the buyer could not reasonably discover. In these situations, a buyer may be able to seek remedies such as contract rescission, damages, or other relief, even though caveat emptor would apply otherwise. Because the operation of caveat emptor and its exceptions depend on the specific facts, representations made, and applicable statutory provisions, buyers should exercise due diligence and seek expert advice before completing a transaction to understand their rights, obligations, and potential remedies. Contact us today for a free 30-minute consultation with one of our experienced team of litigation professionals and let us help you protect your rights.